Members of the military are at risk of losing their careers, their livelihood, for behavior that is often not even a crime in the civilian system. That's why you need to know the facts. You need to know your options, and you need the help of experts when facing military justice.
Welcome to Military Justice. I'm your host, Jim Buchanan. Our guest today is Jonathan Crisp, who's an attorney specializing in military law at Crisp & Associates. Welcome, Jonathan.
Good afternoon, Jim.
Thanks for being here.
Thank you.
Today we want to talk about court-martial. And when you hear that word court-martial, that's kind of an ominous term. What is at risk for a person in the military facing a military court-martial?
Everything. So this is what I have done for 20 years, and this is what I've defended soldiers and Marines and sailors for 20 years, because so much is at risk. It's their freedom, it's their life, it's their career, money, and it is the most serious and significant thing that a service member can face in their career.
How long does that last? I mean, can that be purged or expunged?
If you have a conviction at a court-martial, it is just like a criminal conviction in a civilian trial. It stays with you forever. It doesn't ever go away. The only way in which it could is on appeal, or if you obtain a presidential pardon.
I was going to talk about that. Talk about the appeal process, if there is any.
So, depending on what sentence you get, and depending upon what kind of court-martial you were in front of, you're limited in some of the rights you get on appeal. But bottom line is, in most cases where you're facing a punitive discharge or a sentence in excess of a certain period of time, then you're automatically entitled to a review by the service court. Each court, each branch of service has a service court: the Navy, Marine Corps, Court of Criminal Appeals, the Air Force, and the Army Court of Criminal Appeals as well. They get an automatic review with a punitive discharge, and or a sentence in excess of a period of time. Now, just because they get a review doesn't mean you're going to win, right? And it's much harder to win on appeal, and that's why we always say, listen, you want a zealous, aggressive litigator to go at this at the trial level, so you don't have to worry about going on appeal. That's why we do this.
And you've had a lot of experience.
I've done this for 20 years. I've had well over 140 courts-martial, and this is what I love to do.
So what should you do when you're first, say, suspected or accused of something that could lead to a court-martial? So
service members get 3 rights to an attorney, which is a little bit unique from the civilian sector. They automatically get detailed a military attorney when charges are filed, but that doesn't necessarily mean that that's after the accusation. Sometimes the accusation can precede the filing of charges for months. So you can consult with a military counsel maybe once, and then they just say, well, hey, until you're charged, you're on your own. Civilian counsel, you can also hire civilian counsel in that intermediate time period, and this is where we like to get involved and starting to shape the battlefield well before the charges are filed. What that means is talking to some of these witnesses who are involved. That means telling these guys, don't talk. Hey, CID, NCIS, I represent this guy. Don't ever ask him any questions unless I'm on the phone, and I'm okay with that. And the same thing with the command. I just recently had a case that was out of England where he was accused of sex assault, and he hired me 18 months before charges were ever filed. I was able to preserve certain evidence that was key in getting him acquitted. I was able to ensure that the command had this evidence available to them when they made their charging determination, and it resulted in an acquittal. If he had waited, it would have been a vastly different outcome. I'm positive of that. So
how are courts-martial, that's the correct way to pronounce it, right?
Correct, that's right.
Courts-martial different from civilian criminal trials?
Procedurally, there's a lot of differences. Now, and what I mean by that is you have fewer jurors. And a jury in a military context is called a panel. So how they're selected to serve on a panel is very different. The qualifications are different. The numbers are different in terms of you can have 6 panel members on a general court-martial, and that's enough. And their verdict doesn't have to be unanimous like it is in most civilian, certainly in federal courts and in most state courts. It can be by quorum, and which is roughly 2/3 majority. So you're kind of playing a numbers game when you're selecting how many panel members do you want. The rules of evidence generally follow the federal rules of evidence, so that's not terribly different. But you obviously have very savvy, educated panel members, and knowing military vernacular, knowing service, knowing any of these things that these guys are encountering on a daily basis is important and is very different from a civilian panel. So what are some of the situations or scenarios that would lead to a court-martial? Nowadays, what you're seeing is mostly sex assault. You're seeing drugs are starting to become more common in certainly certain branches, but the overwhelming majority of the caseload that I have are sex-related type crimes, whether it's adult sex cases, child sex offense cases. That is still by far the most frequent. When we changed the, let's say about 7 years ago, it's 2020 now, you saw a dramatic change in how cases were being prosecuted and how they're being handled dealing with sex assault cases which is different from what you're going to see typically in a deployed environment.
Yeah, well, let's talk about that. You're in a deployed environment, you're overseas.
Right.
How does that work?
Those types of offenses are going to be typically violations of Article 92, which is sort of a failure to obey a lawful order or general regulation. You may see, the cases that get the most press and publicity are the ones that involve, say, detainee abuse or classified information. Those cases are much more rare, but they happen because of the environment that we're in, and they are what I would say sort of a failure to abide by a certain conduct, what we call the code of conduct. But normally in an Article 92 violation, it's failure to obey, drinking alcohol when you're not supposed to be drinking or too much alcohol. It may be a question of, not supposed to have sex in certain theaters. Pornography in certain theaters is prohibited based on the country that we're in. Those are the typical things you're going to see in a deployed environment.
So you're talking about personal habits or urges as opposed to denying orders.
Correct.
Okay.
So those are the two distinctions that you're going to normally see.
All right. And then again, if you find yourself in this situation, they want to contact a person like yourself.
Yes, you're never going to do well talking. I have yet to see it benefit a client in 20 years of doing this, talking their way out of an accusation. Usually it's the other way around. They're talking themselves into it and more. So get a hold of a lawyer and don't talk.
All right. Always good advice. Thanks, Jonathan.
All right.
Thanks for joining us for Military Justice. If you're interested to learn more about today's topic, go to mymilitarylawyers.com. Remember, you need to know the facts, you need to know your options, and you need the help of experts when facing military justice.